So these are petitioners are instructors.
Yes, yes.
In physical education, arts, work education. Now we are being paid
Only on the pay scale remuneration.
correct.
The dispute is about the remuneration.
Correct. Now, Lord, we have been appointed by the state of UP after that new act had come into force. The pay scales were to be determined and were determined by the project approval board.
Under which provision of law?
I am just going to read the judgment. I am just going to tell you the judgment notes everything. So I am just going to read it. I'll just give the point in 1 minute and then take your order to the judgment. The project approval board for the academic year 2017-18 said that they should be paid a minimum of 17,000 rupees per month. Now that decision was taken by the project approval board in March 2017. That decision was circulated in May and June 2017. In December 2017, the Special Secretary to UP issues a memo. He says that central government has not given as much money as it should have, and therefore we can't pay 17,000.
Yes, because it is the central government and the funds have to be received from the central government.
The finding,
The funds received, the salary has to be allocated.
so the finding of both the courts is that the scheme is run and operated by the state government. The state government is responsible for all deficient funding, and even if there is some less funding, the responsibility of payment is on the state government. Both judgments are in my favor, single bench and division bench on this point. So, just to complete my narration, so the secretary says in December 17, and he does not send it back to the project approval board, which is a body which comprises of central government.
Order.
He sends it to the executive committee of the UP education project, the project board of the state project. That state project in one paragraph says secretary has said this, agreed, and they reduced the amount to 8,000 and odd rupees, and that is what we are paid. When this happens, we go to the state high court. We say that we have been appointed after a due process of selection. Appointment letter may say part-time instructors. We are.
See, it is a typical appointment. Yearly appointment.
Correct. So therefore, we are continuing on year to year now for the last over a decade. Now the single bench says once the project approval board said they should get 17,000, we should get it for all times. Single bench does not restrict it to 1 year. They go to the division bench. Before the division bench, their argument is only this, that it could not have been for perpetual. It should have been limited only for 1 year. The division bench goes into the reports that the project approval board is competent, also reports that this fund from the central government, number one, is factually incorrect. Whatever central government had promised, it has fully paid. Second, the division bench says, in any case under section 7, subsection 3 of the 2003 Act, responsibilities of the state. Holding that, however, the division bench then says, but it could not have been in perpetuity. It could have only been for that 1 year. 1 year. Therefore,
every year there has to be a threshold.
So therefore, we are agreed by only that modification of the division bench, whereby the division bench has reduced it from perpetuity to 1 year. Otherwise, I may tell your lordship, today we are getting 9. The central government has fixed a minimum wage of 22,500 under the minimum wages act. So what we are getting is far below even the minimum wage. Now, I don't need to read much except the judgment of the division bench. Now, please have the judgment of the division bench at page 5.
You tell us that the operation has to be fixed.
Yes.
By the board.
Yes. Let me just tell your lordships a little bit about ourselves, and then I will go straight to the statutory regime. I need not refer. Division bench has elaborately discussed that point. What is falling to your lordships from your lordships? Kindly at page 6, para 7. The statutory regime, state of page 6, para 7. Junior High School Council
Yes.
Instruction Welfare.
Para
7, page 6, para 7.
yes.
The writ petitioners have pleaded the statutory regime, what your lordship also wants to. So this is completely discussed now in the following paragraph. The writ petitioners have pleaded the statutory regime in the foreshadow of which their rights have arisen. They have referred to the fact that the Parliament has enacted the Right of Children to Free and Compulsory Education Act 2009. By virtue of Section 1, subsection 3 of the 2009 Act, the Act shall come into force on such date as the central government may by notification appoint. Relevant notification has been published in the official gazette on 16 February 2010, notifying the date of enforcement as April 1, 2010. The 2009 Act provides for appointment of part-time physical education instructors for the purpose of imparting health and physical education to children. So our posts are not created by the state government. Our posts are created by the Act itself, where there are more than 100 students that will come further. But I am just just informing your officers. Likewise, there is a provision. Likewise,
Art instructors.
yes, there is a provision in the Act of 2009 for appointment of art instructors to impart education in art and others for work education. The state government issued a government order dated October 3, 2012, by which steps were taken for implementation of the supplementary plan of the Government of India provided under the Act of 2009. The government decided that for imparting education to children in the age group of 6 to 14, for every 100 children, one part-time instructor to teach physical education will be appointed on contract basis. The Act provides it. Act is reproduced. It's not only the state government. The Act will be reproduced subsequently. Now, para 8 and 9 is about us, what we do. It's important also. It is the writ petitioner's case that the state government amended the government order dated October 3, 2012 relating to appointment of physical education instructor, art instructor and work education instructor by issuing another government order dated January 31, 2013. Pursuant to the later order, an advertisement was issued on February 25, 2013 inviting applications from eligible and qualified candidates for appointment as part-time instructors conforming to the National Council for Teacher Education norms about minimum qualification. It is the writ petitioner's case that in response to the advertisement dated February 25-13, they applied for appointment as instructors of physical education. After due selection by a selection committee constituted in terms of the government order, the writ petitioners were appointed as instructors physical education. So there was an advertisement selection process, they were appointed. 9. It is pleaded that the writ petitioners are required to possess minimum qualification as per norms of NCT provided for all teachers, instructors, by NCT notification dated June 10, 2011. The physical education instructors are said to be selected by the same selection committee in accordance with the government order issued by the state government as the one for appointment of other teachers. The writ petitioners work to impart education in order to give effect to the provisions of the Act of 2009. It is pointed out that by some notification dated August 25-11 for instructors appointed to impart physical education, teacher eligibility test, commonly called TET, is not a necessary qualification. The writ petitioners have also emphasized clause 5 of their appointment letter contract, which makes it mandatory that they will not directly or indirectly engage themselves in whole-time or part-time profession or business or enter service of any other employee. It is emphasized that the writ petitioners discharge the same duties as is done by other teachers of the institution. They teach each 8 periods per day, imparting education in all subjects besides physical education, art education. However, they have been remunerated in the past at 7,000 rupees per month. So, full-time or part-time with any other one.
Yes.
And number two, we have said we are doing the same duties which the other teachers are doing. Both these things. Petitioners have also emphasized from here, para clause 5 of their appointment letter, and this is in fact recorded in the order issuing notice in this case. Engage themselves in whole-time or part-time business or profession or enter service. It is emphasized they discharge the same duties as done by other teachers of the institution. They teach 8 periods every day, imparting education in all subjects. Now then comes the act, my lord, sharing of financial and other responsibilities, section 7, which is most important. Yes. Now section 7 subsection 1 says, the central government and the state government shall have concurrent responsibility for providing funds for carrying out the provisions of the act. So the responsibility is concurrent. 2. The central government shall prepare estimates of capital and recurring expenditure for the implementation of the provisions of the act. The central government shall provide to the state government as grant in aid of revenue such percentage of expenditure referred to in subsection 2 as it may determine from time to time in consultation with the state government. So, the central government has to provide grant in aid such percentage of expenditure referred to in subsection 2 as it may determine from time to time in consultation with the state government. The central government may make a request to the president to make a reference to the finance commission under clauses so and so to examine the need for additional resources to be provided to any. Yes. Now 5 is most important. Notwithstanding anything contained in subsection 4, the state government shall, taking into consideration the sums provided by the central government to a state government under subsection 3 and its other resources, be responsible to provide funds for implementation of the provision.
Whatever balance is required, that will be provided.
Yes. So the submission is under 7 subsection 5. It is ultimately the responsibility of the state government. The state government cannot shirk its responsibility by saying, center has not given me and therefore I will not implement. Because even under subsection 1,
Even otherwise, the liability is
concurrent. That's exactly. That's the point. Even otherwise it is concurrent. Now, my lord, if your lordship will see, para 11, the facts are recorded. From para 11.
Yes.
It is the state government, according to the writ petitioners, who are obliged to submit a proposal to the project approval board, which is a body at the level of the central government, set up to implement the mandate of section 7. The writ petitioner respondents have come out with a specific case in para 19 of the writ petition to the effect that they were paid honorarium at 8470 per month during 16-17, approved by the project approval board of the central government. In the next year, ensuing 17-18, the state government submitted a proposal for payment of honorarium at 17,000 per month to the project approval board. The project approval board, by its decision in the minutes of the 254th meeting held on March 27, 17, accepted the proposal under 7.2 of the Act of 2009 and released funds to the state. So they actually provided this proposal to the PAB, which approved it. It is also the petitioner's case that the state government for the year 16-17 submitted a proposal to the PAB to remunerate the instructors, which includes the writ petitioners, at 15,000 per month. The board, however, accepted from the said year monthly remuneration at 8470, enhancing it to 1470 over what is being paid. Then, Lord, this is what we had received. I can leave it. Then, para 13. It is further asserted that the project approval board, which is a body constituted by the Government of India in the Ministry of Human Resource Development, Department of School Education and Literacy, for granting financial approval under the Act of 2009, sanctioned honorarium in its meeting held on March 27 to be paid to the writ petitioners and similar instructors at 17,000 per month. A letter dated July 7, 17 has been issued by the project director, whereby the writ petitioners have been paid the honorarium for March, April, May 2017, as is not clear, at 8470 instead of 17,000. This has been followed by another letter addressed to all district basic education heads. So that I can leave the next 2-3 paragraphs. Then your lordship may have para 16. How the reversal starts. This is how the state government reverses the PAB decision. Para 16. It is the writ petition respondent's case that the Additional Chief Secretary Department of Education Government of UP proceeded to pass an order dated June 2017, whereby it was clearly recorded that the proposal of the state government to pay honorarium as part-time instructors at 17,000 per month for 1780 has been accepted by the Government of India. It is further recorded in the said order that though the demand of Rakesh Patel is for honorarium at 15,000, the Government of India has sanctioned honorarium at 17,000, etc. The writ petitions have pleaded that a case that the order of the Additional Chief Secretary makes it clear, decision to pay 17,000 has been taken. Then, my lord, if your lordship will have para 17 in the middle, it is admitted in para 5 of the said counter affidavit that the PAB accepted the estimate for enhancement of honorarium. The Project Approval Board of the Government of India accepted the estimate of 20,000 crores as yearly outlay for Sarv Shiksha Abhiyan. But the minutes of the PAB, it has been recorded that the Government of India, according to budget, would contribute a sum of 3,900 crores, which shall be released as central share to UP, wherein teacher salary and non-salary accounts would be included. The stand is that the total expenditure on Sarv Shiksha Abhiyan approved 20,000 crores, whereas the total estimate outlay sanctioned under the head of teacher salary is 18,000 crores. Of the said expenditure, central government's figure has pegged to 3,000 crores. It is the government's case that the center has contributed much less than their share, as done in the cases of, has to be done in cases of states like Uttar Pradesh in the ratio of 60-40, central government bearing 60% burden. It is on account of the short contribution by the center that they were compelled to review the proposal. So this is what they say. Then if your lordship will kindly have para 25, what was their case before the division bench? Read para 25. This is the argument. What is their argument before the DB? Para 25. It has been argued by the learned Advocate General appearing for the state of UP, along with Chaturvedi, learning Additional Advocate General and so, that the learned single judge erred in issuing a mandamus directing payment of 17,000 per month to the writ petitioners based on the decision of the PAB for all times to come, inasmuch as the decision of the PAB and the proposal which it was found was limited to 1780. Therefore, no direction would be issued for subsequent years. That's the short argument there is. That's all. Now, more time.
Then we have to see this resolution of the PAB.
Yes, I'm just going to it. May I just take your lordship to the conclusions of the judge, and then I'll just come straight away to the resolution. Because it's your lordship may kindly have para 21, page 21, para 32. Now falls for consideration the question whether the decision of the Project Approval Board dated March 27 to pay honorarium as part-time instructors, including the petitioners per month for 1780, would be reviewed by the Executive Committee of the Parishad acting on the instructions of the state government on account of short funding by the central government. We assume that the central government did not provide the entire funds that were due in accordance with the expenditure. The question is whether on account of short funding by the central government, based on its share regarding expenditure, the decision of the PAB to pay the honorarium would be revoked and reduced. The state government has taken a stand that it has the right to do so under its law, and it has enforced the right through a contract inter-se between the state and the petitioners at the time of renewal of their contract, etc. Now then they spell out section 8 of the Act, duties of the appropriate government. At page 24 top, one of the duties is to ensure good quality elementary education conforming to the standards. Just kindly at page 24 at the top. To ensure good quality elementary education conforming to the standards, this is one of the duties asked from the state under the Act. Then, my lord, para 34 the court says, of particular relevance is clause B of section 8, which mandates that appropriate government shall ensure good quality elementary education. Then the Act itself contains the schedule, which contains the norms. And kindly see page 26, subclause 3 of the schedule. The Act itself provides where admission of children is above 100, one full-time and one part-time instructor for art, health, physical education and work education. So the Act itself, Section 7, your Lordship said what is the statutory framework? Statutory framework is Section 7, read with Section 8G to provide good quality education, read with the schedule of the Act which deals with people like us. Now, my Lord, para 25 is the conclusion that para 35 is the conclusion. A perusal of the schedule would show that in cases of school imparting education for class so and so where number of children admitted is above 100, apart from full-time teacher and others are imperative, the engagement therefore of part-time teachers is an integral part of the scheme of the Act of 2009. A school that is teaching 7-8, which is precisely here, where number exceeds 100, part-time teachers cannot be left out. Their presence to whom the young children is necessarily concomitant of the Act, an integral part of secondary education. There is therefore not the slightest doubt, which otherwise has been accepted by the central and state government, that part-time instructors are governed by the Act. And to our understanding, it is a duty, is para 36 of the state government to provide. Then, my Lord, they go to right to education. They deal with certain judgments. And then your Lordship may have para 40 and 41, which is the conclusion. Yes. Para 40 and 41.
Issue would have been examined.
Yes. On wider parameters, petitioners are confined to right of part-time instructors engaged to teach teachers, etc. Engagement as per existing policy on a yearly basis. Then, Lord, para 41, the court concludes, the learned single judge, in our opinion, has rightly analyzed the position that the decision of the project approval board in their meeting dated March 21/7/17, accepting the proposal of the state government, was a decision taken in terms of subsection 2 of section 7 of the Act. It is also noticed elsewhere by the single judge, and we must do here, that subsection 5 asks residual responsibility to provide funds upon the state government after the central government has made a contribution. Thus, once the project in question and the benefit decision had been taken in the exercise of powers under subsection 2, the state government's case that central government did not provide the fund, the state government cannot absolve itself of the responsibility under subsection 5. So that's the conclusion here. That once the decision was taken by the project approval board, the state government then cannot absolve itself. Para 41 is that decision. Then your Lordship may have para 42, where the counter file by the government of India is reproduced. Para 42. And in para 3 of that counter, if your Lordship will have page 30, para 42, last 3 lines. In paragraph 3 of the counter filed on behalf of the Union of India before the learned single judge, which is an affidavit sworn by Dalbir Singh Under Secretary, it is averred.
So, paragraph 3 is quoted there.
Correct. Now, during the year 1718, I need not read the whole of it, Lord. The last 2 lines. Thus, the complete due central share, as indicated to the state, was fully released during 1780. So,
Cannot be even shortage.
correct. So, the government, the Union of India's affidavit, which is reproduced by the state government, is that what we had promised, we have fully released. Any case, I am not getting into that issue. Then, my Lord, in the resolution of the project approval board is there, my Lord. Then, if your Lordship will have para 45, the conclusion, and I'll show your Lordships, the PAB decision. Now, there is another very interesting aspect of the PAB decision, which I will show you when I go to it. Para 45. Yes, the clear averment in para 3 of the counter affidavit filed on behalf of Union of India and the relevant resolution of the PAB taken together do not spare a shadow of doubt that the project approval board in its 254th meeting held on March 27, 17 accepted the proposal of the state government for payment of honorarium to part-time instructors, which would cover the petitioners. The assertion in the affidavit of Secretary Basic Education that sum of 70,000 was accepted by the PAB in principle is incorrect. The PAB took a final decision to determine honorarium for 1718. It is a concluded decision and not in any tentative, provisional or conditional. Decision of the board is statutory, relatable to powers of the central government under 7.2 of the Act. Decision has binding force. the containment to the conflict are rejected. Then they go, this is regarding, then next para they go on 5. That in any case, even if there is shortfall, our state is responsible. Kindly see para 5. It is also permissible that under subsection 5, any shortfall in expenditure should qualify so and so is to be borne by the state government in the event of central government falling short. Therefore, we of the opinion state government would have to remunerate the commissioners at 17,000. But last para 48 they say, however, it will not go beyond 1718. After 1718, then again the PAB will have to decide. But because it will also be seen in the result, especially with judgment of the learned Sikh judges said, yes, now that PAB decision is placed on the record seriatim by the state government in its specially petition. The Lordship may just have that paper.
Another by the
State. So that is placed on record by them and as an extra P10 at page 206. But the print is not very good. I'm just passing on 2 copies. It's a little dark. I'm just passing on 2 copies. I'll give it to my friend also. The part where I want to read is very black and not readable.
There is a straight.
Expedition. Page is relevant. I'll just take you on. So what is relevant? Firstly, is page. Paging is at the bottom. Page 14.
Yes.
Just kindly have it page 12 onwards. Page 12, the title of the page. Financial issues at a glance. And then kindly come to page 14, para 8.
Releases by government of
Yes, during 1780. The amount provided by the Ministry of Finance and
the central government has released the entire fund.
Yes. And what the board says, let me just read this first 2 paras only. The amount provided by the Ministry of Finance is 23,500 crores. Against the above estimate, central government shall provide to the state government 3,943 crore as its share as per 7.3. The state would contribute 2,622 as its share, matching the above. In order to emphasize focus on quality of education, it is advised 30% of releases so and so. Then second, as per 7.5 of the RTE Act 2009, the state government shall, after taking into consideration the sum provided by the central government above and mandatory matching grant, share, provide the balance fund necessary to fill the estimate for implementation of the Act. It is recommended that the state should meet this balance from its own sources, including additional funds devolved under the 14th Amendment. So the PAB also says, as per 7.5, residual responsibility is of the state government. Now, my lord, kindly have our part and pay. 29. Please have page 29.
और सुप्रीम कोर्ट का ऑर्डर है, थोड़ा टाइम ले रहा है, एकदम शाम को एकदम होता है तो जैसे होगा ना.
It is not only for us that this decision is taken. Now at page 29, clause 4 is teacher's salary. Now total amount is, I don't know, 108 some crore, 18,000 crore. Alright, it is 18,000. My friend is better at reading these figures. 18,000 crores. So the PAB, so the
He is used to dealing
what? So the second part which I am going to say is, when your lordship will see the pullback is only for us instructors. We are the lowest category. Now kindly see, they have fixed the salary for primary teachers. They have fixed it for para teachers, all teachers. We come at the next page, last 3 lines. Next page, yes, where this overpay chart is ending at the top. Part-time instructors, Now, art education, health and work, and they fixed 17,000 rupees for us on as a unit cost. So therefore, and now just kindly see the list of participants at page 31. Page 31.
Yes.
The list of participants is, this is the Secretary Education and Labour MHRD, then Additional Secretary and Secretary Education, then there is Basic Education Secretary, State Project Director, then at 7-8 again MHRD. So they are all a mix, and the number of participants are like 60 participants here. Now kindly see what happens after this. So in June, this is a May letter. In June, the Special Secretary issues a circular saying, please implement it. That is mentioned in the judgment. That circular is not on the record, but Lordship can just note it. The judgment mentions that at page 16 and page 12. 2nd June 17 is the letter of the Additional Secretary, Additional Chief Secretary of the State of para 16. Take this. It is the writ petitioner's case that Additional Chief Secretary proceeded to pass an order dated June 17. It was clearly recorded that proposal to pay honorarium has been accepted by the Government of India and it is recorded, etc. So this was recorded. Then what happens, my Lord? Your Lordship will now come to the state appeal. The pullback. Just kindly come to the state appeal. Annexure P14. This is the first letter written by the Secretary. Page 240. Yes. This is the first letter. After the project approval board, this is where they now pull it back. This is 20th December 17 regarding honorarium of part-time instructor. Now what your Lordship will notice, PAB actually decides on everybody. Pullback is only for us. Now we are the lowest in the hierarchy, getting the minimum, and we are also pinching somebody's eyes. In continuation of scrutiny by government letter of Finance Department in connection with the honorarium of part-time instructers working in upper primary schools, it is informed by a letter dated 14 December that Government of India has approved a total of 20,000 whatever in annual plan budget expenditure under the head of pre-syllabus book, etc. Kindly come to the next page. Government of India has till date released 29,000 lakh of central share. Government of India is committed to pay 3949 crore for financial year 17-18. Government of India releases central share in one-time payment and not item-wise. Increasing honorarium of part-time instructors up to 17,000 per month will increase the burden to 57,874 lakhs annually, out of which state share will be 23,000 lakhs. In financial year, there will be an increase of, I think it's 116 crores as state share. For release of remaining central share, letters are sent by Honorable UPCM to HRD. Then those letters are mentioned, my Lord. Then last three lines, since lesser amount will be received as central share, additional expenditure shall have to be borne by the state government. In view of the above fact, consequent upon increasing honorarium of part-time lecturer of upper primary school up to 17,000, reconsideration is necessary for the following reason. Before putting on proposal of increasing honorarium in the meeting of the executive committee of the Sab Shiksha Abhiyan, written consent of Finance Department was not obtained. Government has given consent for increase of honorarium but has not released the central share. Then in compliance of the order passed in SLP, etc., he says, the last para he says, therefore in view of the facts I am directed to request you to take action to put up the matter of increasing the honorarium in upper primary board where enrollment of student is more than 100 for reconsideration by the executive committee of the sub-sheet. So he sends it to the state executive committee. Now the state executive committee meeting is on the next page, not P15, at page 250, the state executive committee. And what the state executive discussion, there is no consideration. There are, my lord, as per the signatures, 2 or 3 members it appears, my lord, to me. Oh, very good. Next. Yes, state government. Yes. Now, reconsideration of decision of increase in furtherance of government letter dated 20th December, while reconsidering the decision taken by the Honorable Committee pertaining to increase in honorarium working in upper primary school, committee grants approval to pay 9,800. So the PAB decision, which is a decision under the 2009 Act, a committee set up, they are just in one para they have. So no rationale, no justification, how much is the less fund, what is happening, and it's all state government directors and additional directors and research assistants who are present. After this plot, then at P16 they circulate these minutes at page 258.
And started with cutting salaries. There is a resolution of the Executive Committee of the Education Board of the, and there is a PAB resolution. Now, under the statute, which would prevail?
The PAB resolution, because there it is a concurrent, that is
Any provision?
bro, that is section 7
Will take the measure.
7.2, that is 7.1 and 7.2, that is where it has to come from. Yes, 7.1, the central government and state government will have concurrent responsibility for providing funds.
Yes.
And then the central government
Get the authority to decide on the already.
7.2, the central government shall prepare the estimate of capital and recurring expenditure for implementation of the provisions of the Act. This is the provision. The estimates for capital and recurring expenditure has to be prepared by the central government. Therefore, the project approval vote goes from 7. Because this is an expense. We are employed in the 2009. The schedule to the 2009 Act creates our rules. Now, the 9 Act itself says we are a recurring expenditure under the Act here. We are not a capital expenditure. Set up schools, make buildings, that will be capital expenditure. Here we are recurring. So according to me, under section 7 subsection 2, the recurring expenditure for implementation of the provisions of the Act has to be prepared by the central government. And the central government has set up the project approval board where it calls the representatives of the state government and takes a decision. Because all expenditure, if your lordship will see the PAB decision, all kinds of expenditure here, if your lordship will see, to consider the annual work plan and budget of the Sarv Shiksha Abhiyan for the state of UP. That was the scope of this meeting. So the entire annual work plan and budget of the Abhiyan has been worked out and fixed under this. Now, if the state government is to get the power to unilaterally go and keep on tinkering and reversing and setting it aside, it will disturb the provisions of the Act completely. And so therefore, my lord, my submission is, this decision of the PAB directly flows under section 7 subsection. And the Sarv Shiksha Abhiyans have been created under the provisions of this Act, according to me. So, my lord, after this order comes, then we go to the High Court and file the writ petition. Our writ petition is at page 268. They have raised some kind of a plea that what we said in our order while issuing notice that we are full-time and we are working full-time and doing the same job did not speak before the High Court. Just at page 272, if your lordship will have, in our writ petition, we have specifically made those amendments. Correct. Lordship will have para 9. It is relevant to mention that after the appointment, petitioners are regularly working as instructors under institution, upper primary school and there are no complaints. It is further stated, and as per the government order dated 31st January 30, other subjects are also allotted to the petitioners by the principal. They are regularly taking the classes. Then, para 12 at page 273, as per clause 5 of the appointment letter issued to the petitioners, it is mandatory for the petitioners they will not directly, indirectly engage in any other whole-time or part-time profession or business or service of any other employee. And then 274 para 15. And the same duties that are being discharged by the other teachers of the institution. They are also teaching 8 periods every day in school allotted to him for all subjects along with so-and-so, for which he is appointed, and getting only 17,000 rupees per month. 7,000 per month. These are the amendments which we have made. In any case, our appointment order is also very clear, which says the same. So, Lord, in all this conspectus, my submission is that under section 7, sub-clause 1 and 5, it is the concurrent responsibility by the state and the central government to provide funds, and in case of any shortfall, then it is the state government's responsibility to make that shortfall good. Number 2, under section 7, subsection 2, the recurring and capital expenditure is to be determined by the central government under the Act. So therefore, the project approval board is a body constituted by the central government, and incidentally, both the judgments support. Single bench and division bench is in my favor on this. I had only come for the short point that it should be continued in perpetuity. I'll just address that also. So therefore, the recurring and non-recurring capital expenditure is to be determined by the central government, which the central government does through the various project approval boards set up for each state government, where the state government is also a part of that board, and a decision which is taken there would bind the state government. And in any case, it cannot be undone by the state on its own, unilaterally, without even taking the central government into confidence. Third submission, our posts are actually envisaged by virtue of section 8 read with schedule of the Act itself. The Act schedule itself says we are to be appointed. So we are also, and the Act is under Article 21A, promote primary education in the country, which is even otherwise made into a fundamental right after Modi Jain and others. We are appointed in terms of the Act to perform the functions of the Act, and therefore, my Lord, 7.2 will apply to us on all fours. And the other limb of this argument is, my Lord, leave aside everything else. 9,000 rupees a month, Lord, it is 1/3 of the minimum wage. I have to raise a family. I am a teacher in a school. Please see my appointment letter, what it tells me to do. Just kindly see that letter, Lord. In fact, when notice was issued, that is what your lordships had seen. Kindly see page 83. Yes, my page 83. Now it is very easy to say that you are a yearly employee, 11 months. I have been working, Lord, from 2013 onwards. We are in 12 years have gone by. In fact, while making his written submission, my learned friend has even appealed to your lordships to give us regularization, but I said that's going a little far in this proceeding. We have not claimed that. But at some stage, we may be entitled to make that claim also.
So where is that you were not to undertake any other act?
Yeah, I'm just going to read that. I'm just going to read that. Kindly see page 83, para 4 and 5. That an employee during the whole tenure of service will devote time and attention to the work in the school. The employee will not directly or indirectly engage in any other whole-time or part-time profession or business or enter into the service of any other employee. Lord, this is what we are expected to do at 9,000 rupees a month. And we have the notification for the...
That's really 9,000
work on that in that 9,000, not to accept any work. Yes, lead your family with 9,000. Correct. That's what the state government wants to do. Correct. Now, Lord, I have just made this small compilation of 3 judgments, Lord, visa judgments, where your lordships have said, part of a minimum living wage is essential. Otherwise, it may amount to forced labor. It is therefore clear. Now, the first one is, and shall I just leave this, your lordship, and see this? These are general principles, Lord. I have just cut out 3 judgments. Paras I have reproduced, but the judgment is also there.
Pass on the 3
Yes. So, Lord, I am grateful that your lordship has spare time to hear us somewhat early in the morning. I have been
Mr. Singh.
Is an but I quoted in my submission product. Just one. Lord, minimum wages act notification at 24,000. Would your lordship like me to leave that also? Minimum wage fixed by the government of India today is 24,000. We are getting 9,000 rupees. Yes.
Right.
Yes.
Yes, Mr. Singh.
But Lordship, I tell you, on page 3 of my return submissions.
You are facing some problem.
Rule 3 I quoted in the submissions. Rule 3, Rule 20.
Where are your written submissions? Your cases, 1 point.
1 point, page 3.
Page 3 of your written submission.
Rule 20 on page 4. Page 8.
In which case?
No, I had passed on some other earlier case.
Includes fees in 14.2. 14.2, I think.
No.
1.2 is the asset.
1.2.
1.1 is your asset.
1.1.
1 is my asset.
1.2.
Whether there is any written.
On an earlier occasion, I had passed on, but I had
Yes.
passed on another copy.
All right. Pass on the another.
Lordships are pleased to have on page 3.
Just wait.
Facts are leading salary and allowances are other.
You are reading paragraph?
On page 3,
Page 3.
submission part.
Yes.
It said the salary and allowances and other conditions of service of teacher is regulated by Rule 20 of the right of children to free and compulsory education, which is quoted below. Now the central government and the appropriate government. Now appropriate government according to section 2, it is state.
State government.
Appropriate government or local authority of the case may be will notify terms and conditions of service and salary and allowances of teachers, schools and other managed by them in order to create professional and permanent cadre of teachers. Now we will come to next page. This is Rule 3. The scales
of pay and allowances.
self-medical facilities so and so shall be at par or similar qualification workers. Other teachers are getting more than 20,000.
How do you establish that other teachers are getting 25,000?
Let them there. This is my information. I am not getting it. But my information is that they are getting more than 20,000. Now, Lordship will kindly consider it is evident from some Rule 3 or Rule 20 that the scale of allowances, benefits, including pension of teachers, shall be at par for similar qualifications work. The honorarium of 9,800.
Or is not at par?
Not that is it. And one thing more, clause C, I have quoted a Supreme Court Constitution by judgment. Can I be excused only for 2 minutes?
Yes, please. You have completed your.
But I want to hear my
Right.
But the Lordship may have clause C. The respondent cannot take the plea of paucity of funds when the question relates to fulfillment of their constitutional obligations under Article 21A of the Constitution, remits provisions of Act 35. The division bench of the High Court was not justified in
payment of already 17,000 per month population to quoted was the recent free in addition to free education and other financial assistance, they shall also be given books for and other necessary benefits so that the object of Article 21 is achieved.
Yes, the government cannot avoid the obligation to pay salary
That is what the
on account of shortage of funds for
but that is what the Constitution will inspire our profession. But these are the only submission and my friend has already said.
you supplemented.
One supplementary submission remains. Road SLP, state SLP, volume 509. One submission is the counter filed by the GUE. They have said we have all the dues has been 36 on 509.
What does it mean? All the dues have been cleared?
The state government has given the affidavit. We have cleared all the dues. What are the my
But that is not correct.
The affidavit is given. Affidavit is given. State affidavit is given. 509. Second is paragraph 36.
Because as far as what Mr. Singh had just attributed, he was talking about the rules for 2010, wherein this rule has been made for union territories.
See the appropriate government, addition of
Yes. Your Lordship has the rule. This aspect, only on Rule 20. If your Lordship sees what my learned friend was reading, was the right of children to free and compulsory education rules 2010.
Yes.
Now, this, your Lordship, if your Lordship sees, now this has been made, if your Lordship sees here, that means so and so, appropriate government is clause 2D, my lords. Appropriate government, unless otherwise specified, means government of a union territory without state legislature. These rules, we are governed by the 2011 rules of the Uttar Pradesh
you
right of
kindly see the act, section 2 of the act.
Yes, we are coming to the definition.
This is the rules.
Appropriate government means now see in relation to school other than the school mentioned so and so
Correct.
established by the state government.
Correct.
Our school we are teaching one they are established by the state government, not by the union government. That is why I say this appropriate government is state government in my case.
Unless otherwise specified means government of the union territory.
Appropriate government in the act. The definition is different to the rules which have been framed by the government of India or union territories.
Lordship will cross to
Central government can also notify the
Are covered.
clause 2, your Lordship is clause 2 and relying upon clause 2.
follow set of medical bill.
My friend is reading clause 1.
You will apply this rule.
Clause 2 of subsidiary
Read the definition of the appropriate government in the rules in consonance with the definition contained in the act.
As far as the state of Uttar Pradesh is concerned, because we are governed, the rules are Uttar Pradesh right of children, free and compulsory education rules of 2011.
Yes.
So this is the rule below which is there. Now this rule what my learned friend is reading, because the definition in the act, if the appropriate government something else, but these rules which have been framed by the government of India are only and only for the union territory below the country. So therefore, using this,
We have to read them together.
because if your lordship sees, then below the kindly see 2D then of the rules. Section 2D. Please see what is this? Because these rules may be called the right of children to free and compulsory education 2010. They shall come into force on the date of publication. These rules, unless the context otherwise requires, act means right to children in free and compulsory education. And the party so and so, appointed date so and so, appropriate government. Appropriate government,
unless otherwise specified, means government of a union without state legislature. Now, under section 38 of the Act, total districts have been created at 11 and been governed. Now, to one aspect.
Mr. Singh has completed.
Yes.
And the argument advanced on Mr. Patwari.
Yes.
Argument of Mr. Singh or
Logic. Now, 5 aspects need to be considered here. The facts which have been.
First of all, you tell us how can you fix the salary or remuneration of a teacher, whether a part-time or a regular teacher,
Yes.
below the minimum wages.
Look, now, as far as that is concerned, in fact, government of India.
You are teaching them, treating them below the wages also.
Looks, as far as the government of India's rates are there, the government of India is making 7,000. We have increased it. It is the government of India's rate of 7. Please appreciate it.
Where 7,000?
Yes, it's 7,000 by government of India. We have on our own have increased it. Please note the kindly appreciate.
7,000 is the rate for what purpose?
For part-time teachers. For these part-time teachers,
No, that is what we are asking. You are treating part-time teachers even inferior to the daily wages.
looks what looks. It's the government of now.
Yes.
The central scheme looks.
You mean the government of India and the government of the state of UP.
As far as state.
Tomorrow you will say we'll give you honor. Enough, happy with it. This is trade, Mr. Council.
Looks very kindly.
If you say that the central government is giving 7,000, we are more kind. We are giving 8,000 or 9,000 more than the central government, and therefore we are in a better condition. Either central government of sorry, Mr. Council, sorry to say, maybe little harsh, but I understand what is from the logical. Is it even stands to reason? Now that, okay, we are paying you 7,000 or 8,000 or 9,000, which is lesser than a minimum wage or even a casual labor, and you expect that you work in this and then don't take any employment as a part-timer, lead your family in 7,000 and be happy with it. Tomorrow you will say, we honor you, give your appreciation certificate, be happy. No money, we are giving full honor. We'll felicitate you.
At one place you want to give free education to everyone.
Yes.
Education is on the priority.
Yes, Lord.
Then you appoint teachers with such conditions where no one will come and volunteer to work. So will you not negate the purpose of the Right to Education Act?
With the greatest of respect, no one had put a gun on them. They have come, Lord.
No, not putting a gun.
Secondly, Lord, and your lordships have said that the terms of the contract between the parties in such matters, Lord, tomorrow they cannot say, no, I had signed it for this reason. Well, this is a case. Your lordships have will show your lordship all the judgments that whether in the such fiscal policy matters, your lordships have said that he will not interfere.
He will hold the contract to be violative of Article 21.
Now, look, your lordships have also, first, your lordship has said as far as policy matters are concerned, fiscal policy matters.
You are in a dominating position. Whatever condition you want, you can impose.
Those will kindly see. Take 20,000 crores in the estimate outlay.
Increase your estimate.
I get increased it to 20,000 crores. With you're keeping in mind that the 60% of this amount has to be given to me by the government of India. Because there is a 60-40, there is a GO.
That either you run the scheme or you abolish it.
Because this scheme is there, I am running the scheme.
You don't provide education to anyone.
Because I am.
There are philanthropists in the country. They will supplement the state functioning of the education.
That's not the
We
case.
don't want education from the state.
That's not the case here. The case here is that you should kindly see patient for a minute. The government of India says for Sarv Shiksha Abhiyan, we will give you 60%. Governor keep on estimate. He sent the project approval board. Look, it is said with this impression in mind that the 60%, that is 12,000 crores, will be paid by the government of India and the state government will have to pay 8,000. Today, my lords, what happens? This project approval board.
See, this question will not arise. The moment the liability is concurrent.
Yes, my lords.
We are not, this is your internal management. Whether state will pay or the central government.
Yes, my lords.
The liability is concurrent. Mr. Patwalia has pointed out that
Yes, my lords.
when the liability is concurrent,
Yes, my lords.
then the state has to pay, and whatever shortage is there, you may recover it from the central
Because
government.
the time we see the act, what it says, we have to look harmoniously, that's true.
Right.
All the section 7, we cannot do only to section 7 and 5. We have to read the entire section.
Read the entire we will go through.
Yes, with you. Yes.
Want to play section 7?
Well, the entire section 7 will read.
Mr. Patwalia also read the entire section 7.
I'll say why. As far as section 7(3) is concerned,
Yes.
the central government shall provide to the state government as
Read the whole of it.
the sharing of financial and other responsibilities. The central government and the state government shall have concurrent responsibility for providing funds for carrying out the provisions of this act. The central government shall prepare I'm so sorry, section 7, subsection 1. Sharing of financial and other responsibilities. The central government and the state governments shall have concurrent responsibility for providing funds for carrying out the provisions of this act. The central government shall prepare the estimates of capital and recurring expenditure for the implementation of the provisions of the act.
Yes.
The central government shall provide to the state government as grants in aid of revenues such percentage of expenditure referred to in subsection as it may determine from time to time in consultation with the state government. Now, Lord, kindly come to my SLP at page 202. What the government of India has decided is that they will give 60% of the total expenses. Now, Lord, this is 40% is what has been given. So this is an idea which needs to be followed, that 60% central government and so therefore 40% the state government will have to give. Now 7(4). Now in says the central government may make a request to the president to make a reference to the finance commission under subclause D of clause 3 of article 280 to examine the need for additional resources to be provided to any state government so that the state government may provide its share of funds for carrying out the provisions of this act. Now clause 5 which should not be read in isolation what is being done. Notwithstanding anything contained in subsection 4, because the purpose of subsection 4 is that in case there is a deficiency or the central government matter will be referred, it should be referred by the Finance Commission to the President of India for allocation of those funds. And only for that reason 7(5) has come into picture that look, the provisions of the act needs to be followed only because it has been pending with the Finance Commission. Under 7(4), the state government should not stop and make the payment. Please float with kindness. Not read subsection 5. Yes. Notwithstanding anything contained in subsection 4, the state government shall, taking into consideration the sums provided by the central government to the state government under subsection 3 and its other resources, be responsible to provide funds for implementation of the provisions of this act. Now, Milords, may kindly see as far as page 202 is concerned, 60/40 is there.
So it also gives some liberty to state but
Look the recommendation, how it has happened from page 206 on my SL. This is the state's SLP. Yes. It was 206. Yes, but fine. The 254th meeting of the Project Approval Board
Better copy is supplied by Mr. Patwali.
Yes, Mr. Patwali had given a
Better copy.
that is at page 206, the first page, 15th May 2017. The 254th meeting of the Project Approval Board of Sarv Shiksha Abhiyan was held on 27th of March 2017 under the chairmanship of Secretary in conference room number so-and-so to consider the annual work plan and budget of Sarv Shiksha Abhiyan scheme for the state of Uttar Pradesh during the year 17-18. Now, Milords may kindly see thereafter, if your lordships come to page 200 in internal page 13, they are the essentials, Milords. And your lordships had asked that what provision was introduced. At 219, because if your lordships have the table, that is internal page 14.
Yes.
Your lordship sees the table, this is category 3. Where salary is 18,028, 18,280 odd crores.
Yes.
So the total grant estimate which has been made is 20,000 crores. Now this chart, your lordship will find it 234 and 235. The Patwali Act. Now you have to kindly see what the ABs does. Thereafter it says total estimated budget of
That total is of all these 1, 2, 3 category.
yes.
So it includes not only salary, it includes the books, uniform, etc.
Oh, I know. Because item 2 at 290, internal page 14, if you lordship sees, item number 2, the top in the table,
Teacher salary.
that is 18,000 crores. And the list which has this amount has come at page 230, 234 and 235 would be Milords, internal page 29 and 30. Wherein this chart has been given about the salary of the teachers. You have to kindly see what thereafter at page 14, total estimated budget of 17-18. The PAB estimated an expenditure of 20,000 crores under the scheme for 17-18. Now please see the actual release by the Government of India which comes thereafter. The amount provided by Ministry of Finance at so is 23,500 crores for the entire country. So, Milord, this PAB, I have sent a proposal of an estimate of 20,000 crores, which they say it is estimated the budget of the entire country under the Act is 23,500 crores.
Why should we go into the entire budget?
No, because it has proceeds.
What the PAB recommended is salary at the rate of 17,000 per month, and that was accepted by the union government.
Well, it was not with great respect, I'll come to that. If your lordship
But fine on that. Now, if there is a decision or a resolution of the PAB,
yes,
how the secretary can reverse it or may dilute it,
yes. Now,
that is the only question.
yes. Your lordship will kindly see para 8, looks internal page 14. The amount provided by Ministry of Finance is rupees 23,500 crores. Against the above estimates, central government shall provide to the state government is 3,943.40 crores as its share as per section 7(3) of the RTE. Now, as per its share is 60% below, and that is why the next line. The state would contribute 2,622.933 crores as its share. State share matching the above central share as per the existing fund sharing pattern of Sarv Shiksha Abhiyan. So, Milord, what has actually been done by the central government is that they have made it 6,566.53 crores for the entire allocation, out of which they gave me 60%. And that's why they are saying that we have given our complete due. So therefore, Milord, kindly see this para 8 again. The above central as per the state contribute 2622.933, that is my 40% out of 6,566 crores, my lords.
We apply the principle of pay and recover.
Last line of the next one, I will read the entire, look at IDC. In order to emphasize focus on quality of education, it is advised that at least 30% of the release in 17-18 are spent on interventions under category 1 and category 2, which is category 1 and category 2 are about textbooks and teachers training and all those things, which is at page 13. Now, as per section 5, section 7.5 will come into picture, only and only when if the central government itself would have, there is no reason why the central government will estimate and approve 20,000 crores, but say I am giving 4,000 crores, which is my 60% share, because then it comes to only 6,500 crores. Today, the state government cannot be saddled. By this use, I asked myself a question. I sent a proposal to make 1,000 schools. I give a budget of 50,000 crores. This PAB will approve. Yes, this is very good. I am approving it, but I will give you only 1,000. So you take 49,000 crores. So I cannot. The state cannot be saddled with this huge amount. And look, your lordships have said that these are matters of policy. The state government will have choice. And all those judgments before the lordship. Look, this cannot be done. 50,000 to 1,000. It says, your lordship, we are asked to pay
Funds or no funds.
Yes.
There is a resolution of PAB that the part-time instructor should be paid 17,000 per month. Why you will not implement that?
Now, my diary
That is the short question.
yes, that's the I have to see all my resources.
Even if you don't get any budget from the central government, you are as a state government running these schools, you are appointing the instructors. Why you will not pay?
Because because this is a central scheme. This is a central scheme.
So if the state government is facing difficulty, they can write to the central government, we can't run your scheme. Please withdraw it from our state.
Here, it can a project approval board which had the total budget for the entire country.
You see it from the other angle. Can you compel a teacher to work on 9,000 when the daily wager is getting 24,000?
Because they are, in fact, if your lordship sees that, they are part-time teachers.
They are part-time teacher, but with a rider that they will not take any employment anywhere else.
Because these teachers are appointed in their block itself.
Yes.
So it is not that I am sending him to some other place.
So you are not sending him. You are not sending, but restricting him that to work only on this 9,000. Take another thing. Pull it on in the 7,000. You club your success. Get the additional funds. Match it with the central government.
I can match only because in fact,
So how you can say?
because it's a promise made to me by the central government that they will make the payment. They are not making the payment. I appreciate this cannot be done by if then the central government has to come and say, yes, I am giving the money. Because I cannot be saddled with this much of amount. It's not only this aspect. Any
No,
aspect.
we are not settling you. See, whatever amount has to be paid to the teachers, you pay. And if there is a shortage, you recover it from the central government.
Kindly see what it says. They are saying that I have paid my
We will apply the principle of motor accident. Pay and recover.
constitution.
Pay and recover.
With the substitution government.
They have said it on the central government that we have paid the full amount, which is wrong, which is absolutely so that means if the central government saying that they have paid us 12,000 crores, is this what my learned friend is saying? They have not, they themselves say that the entire budget of the country is 23.
Out of that issue with the central government.
Therefore,
I will go into all this.
for the reason that the central government has, if given 3,943 crores as its share, the amount comes to 6,566 crore. It cannot be because they are saying I am giving 60%, your state share is 40%, it should come to 2,600 odd crore. So this totals to around 6,566 crore. That we can do. I cannot be asked to pay 16,000 crores extra. Now let us kindly see what has happened here. After this BAB you see what has happened. The Lordships have the SLP of the state government, which my learned friend has.
No, BAB recommendation was accepted by the government, union government.
Government.
It has.
Yes. Your secretary has accepted the judgment reports.
Yes.
कल हाई कोर्ट में सर अकेले थे कल
This has been accepted by the government of India. Now, what is letter, Milords? I need to see, because I'm sorry I haven't seen this letter. But, Milords, what
You verify the correctness of the letter.
Yes. Now, please see, because while thereafter, we had to look into this aspect. Those may kindly see at page 246, why we had to review what my learned friend
Page 46
of my SLP, Lords. Yes. 246 and page 247. I'll give all the reasons why we had to look into this aspect. Lords, 247, paragraph 2.
Yes.
In view of the above fact, consequent upon increasing honorarium of part-time instructors of upper primary schools up to 17,000 per month, reconsideration is necessitated for the below given reasons.
Yes.
Let me kindly see first. Before putting up the proposal of increasing honorarium of part-time instructors of upper primary schools in the meetings of the Executive Committee of Sarv Shiksha Abhiyan, written consent of the Finance Department was not obtained on the file, whereas state share is also involved in the matter. So, it is 20,000 crores. The state share is 8,000 crores.
So whether in pursuance of the letter any reconsideration has been done?
Now, this reconsideration has been done by this committee of the state government.
No, how? And not BAB. The recommendation is by BAB. Reconsideration has to be by BAB. These reasons are Prasad, 1 minute.
Yes, please.
Even this, our first reason,
Yes,
we have something to say. Somebody failed to take permission, consent for this. Is it the fault of the teachers? It is for the state and that concern office. If your officer committed mistake, take action against him. Isn't that you have taken any action against somebody? Get the mistake rectified.
Thereafter, we will kindly see. Because I understand what's falling out. I don't want to get into this aspect because this was in 2017, which means I don't want to say, but it was the election year, so a lot of things had happened. By such recommendation, I don't want to get into that.
The focus of the government is on the elections only. Many things.
So that is why the recommendation, I don't want to get into that as of now, but it was because of the 17 elections. Now, I will see. The government of India has given consent. Look, this is being said on the premise that the project approval board is a statutory body which is giving approvals.
Yes.
For us, Lord, BAB is a recommendatory. BAB is not a statutory body because
May not be a statutory body.
so it's recommendations.
Yes.
Can that be?
Recommendations are not binding, but once the recommendations are accepted, then they become binding.
Yes.
You accepted the recommendation.
The kind of government of India has given clause number 2 has given consent for increase of honorarium of part-time instructors, but has not released central share for payment of honorarium. Due to non-availability of central share, it is also difficult to release state share. It is also to be mentioned that government of India has not taking full central share for the last 2 years, despite the fact that government of Uttar Pradesh has been constantly making efforts requesting the government of India for release of money. In compliance of order dated 25th of July 17. The fourth one, in right to children to free and compulsory education, provision is made for 45 hours per week, including preparation hours, whereas in the government order dated 13 and 14 pertaining to selection of part-time instructors, it is minimum 24 hours. Therefore, period of teaching for part-time instructors is shorter than that of a teacher or a shiksha. So, Your Lordship, this to Your Lordship that we are doing the same job, but this is also one of the reasons as to why it needed to be reconsidered. Because if money is not in this government of India and the additional burden in form of increase in honorarium is to be borne by the state government, process of state share is not made in the budget of financial year 17-18. Therefore, in view of the given facts, I am directing to request you to take action to put up the matter for increasing honorarium per month for part-time instructors working on contract basis in for my distribution code, where enrollment of students for the when the executive committee of Sarviksha Abhiyan and the project approval board because after that, the minutes of the executive committee, they did so. Immediately thereafter, when the GO was issued, the rate petition was filed. As far as the rate petition is concerned, and 17,000 should be given.
So that is the short question.
Yes. Now, you don't kindly see.
See, the basic argument is the PAB has recommended payment of rupees 70,000 per month for the years 2017-18 onwards.
Yes, Lord.
So why are you not paying that amount? Now, only the letter saying it requires reconsideration for such and such reasons.
Yes,
or that the central government for the last 2 years is not releasing the funds is neither here nor there. You cannot take shelter of all these pleas. If there is any difficulty on your part, there is shortage of funds, you recover it from the central government. Yes, but ultimately the payment has to be made by you. Double engine government. Yes, Mr. Singh is right. What is double engine?
Smaller engine is center is also part of the very same.
Yes.
The government of India is not here.
He is very right.
And the smaller engine will
Everyone is shouting double engine sarkar, double engine sarkar. What is double engine sarkar?
the 8 hours can move the 5. They can accept 8 hours, not more than. The bigger India is reference on BC plus.
No.
I beg to appear for union.
She will appear later on. You finish?
Yes, Manoj. Now, Manoj, kindly,
She will supplement your argument.
Manoj. Now, Manoj, kindly see page 300 for a minute, Manoj.
Page
300 of my SLP paper, right? Yes. Correct.
See, these secretaries should also not create hurdles in the implementation of these schemes. See, these are all welfare, beneficial schemes. You have a special act for that.
Absolutely right.
You want to make this act redundant?
Because in fact, we are trying,
As well as spent by so much money on many other things, but not on education.
because in fact, we had set an estimate. It was our estimate which had gone to the center. The reduction is also the lowest that school instructor
Talk about
his salary is reduced.
Talk about Viksit Bharat. How can Bharat be Viksit unless it takes care of the education?
Because we are trying, Manoj, but Manoj, it has to be Manoj under the schemes.
You say पढ़ेगा इंडिया तो पढ़ेगा इंडिया, पढ़ेगा ही नहीं तो कहाँ से पढ़ेगा?
It's absolutely correct.
पढ़ने ही नहीं दे रहे हम.
Manoj are absolutely right, sir, but it's a scheme wherein Manoj we are, it's a central scheme. We are trying to enact it. We are trying to follow everything which is supposed to. But because if we are not getting from the central government the funds to take on further the scheme, how can we do it? It becomes very difficult. I will see. It's not a amount.
दूसरा
12,000 crores, I am saying that I said a project outlay of 20,000 crores on the premise that you will give me 12,000 crores.
In 300 you are drawing our attention.
Yes, please. You will kindly see, this is by Government of India Human Resources. Respected Madam Sir, I am glad to inform you that the Cabinet Committee on Economic Affairs in its meeting held on 28th of March 2018 has approved an integrated scheme for school education extending from preschool to class 12 for the period from 1st April 18 to 31st March 2020. This central sponsored scheme will subsume the three centrally sponsored schemes of Sarv Shiksha Abhiyan, Rashtriya Madhyamik Shiksha Abhiyan and Teachers Education. The objective of the scheme across all levels of schooling are so and so, then para 2 minutes. The schemes will be implemented as a centrally sponsored scheme by the department through a single state implementation society at the state level. The fund sharing pattern for the scheme between central and states will be in the ratio of 19:10 for the 8 northeastern region states, which Arunachal Pradesh, Assam, and the Himalayan states,
60-40 for all other.
60-40 for all other states and union territories with legislatures. 100% central share will be provided to UT without legislature. This is in accordance with the recommendations of the subgroup of CM on rationalization of central sponsored scheme. Now we will kindly come to page 303 below. If your lordships have looked 303 lords, the activities, program, and the financial. Your lordships have got looked page 307. So 303. Look this kindly see. Program, norms. There will be no separate card of teachers for financial. The central share under the scheme will be restricted as per the prevalent fund sharing pattern based on the financial norm given here. Part-time teachers for arts, physical and health education and working education up to 7,000 per month. This is what the central government is saying, that this is my share. Now, this was never, no one has challenged this rule. Now this decision, now today we are being asked, the central government says, sorry, 7,000 ain't nothing doing. And this, with greatest of respect, is nothing but the reconsideration of the recommendations of the project approval board by the government.
From this house, get it.
Below the kindly see how it starts. Plus page 300 for a minute to us.
303, you come to 303. 300 you have read it.
303 is part of 300. Yes. Plus page 300, this is a letter by the government of India to all the education secretaries of states and UTs. What they say. The scheme will be implemented as a centrally sponsored scheme, so and so 60-40. In 60-40, last and the lordship sees, yes, I'm thankful to my friend. 302 is regarding the salary of teachers. It starts from 302. Teacher's salary structure, if lordship has the financial norms. Salary structure will be determined by the state norms for salaries. The central share under the scheme for teachers' salaries will be restricted as per the prevalent funds sharing pattern based on the financial norms given below. For primary teachers, 15,000. Upper primary teachers, 20,000. For secondary teachers, 25,000. Head teachers, 25,000. Headmasters, principals, 30,000. Part-time teachers for arts, physics and health education and work education up to 7,000 per month.
This is not the total salary. This is the central government share.
Yes,
This is not the total salary. This is only, my friend is trying to show as if salary is fixed at 7,000. Please don't try to, just kindly see page 302. Salary structure.
This is 60% share of the central
No,
government.
here they are now moving from 60-40. They are quantifying their share. They say, just one, they say salary structure, I'm reading 302. Salary structure will be determined by the state norm. They say state norm will determine. The central share under the scheme will be restricted as per prevalent fund shaving pattern given below. So for primary teacher, central government will give up to 15,000 only. If 60% is less, it will become less. If it is more, they will freeze at 15,000. Because the salary will be as per state.
For part-time, it will...
The part-time, the maximum central government sharing is 7,000. And here he wants to give us only 7,000.
No. 7,000.
But this is complete red herring.
This means that the central government will go up to 7,000 at a 60% share. That is what I'm saying.
No, but this is separate.
We have followed.
So therefore, that is
We understand what Mr. Patwali is saying, and we are also following you.
so below 7,000. What it says is 7,000 is the maximum ceiling of 60% share.
Now make your submission and leave the rest for our lordship.
Now, Milords, after this, Milords, your lordships, Milords, there are certain judgments, Milords, wherein your lordships have made that policy matters, especially the fiscal policy matters or pay fixation
Should not interfere.
Your lordships, Milords, your lordships have held, Milords, and Milords, if your lordships will give me some time, there are under clause 7(4), even if there is some shortfall, I cannot do anything. It is only and only the central government.
Just a minute. There is a query by my brother.
Lordship.
Now, if what Mr. Patwalia and you are submitting before us,
Yes, Milord.
if this 7,000 is the maximum limit of the share of the central government,
Yes, Milord.
this will be 60% of the...
Yes, Milord. If the maximum.
The total amount is your 40% share.
So 7.
What are you doing with that?
Total amount. 7,000. Milord, kindly give me half a minute, Milord.
No, don't take 7,000, 40% of 7,000.
No, not 40% of 7,000. 7,000 is 60%. 60%. The total amount I have to calculate. 100%. Right. Okay, 200. 11,666.
You are not even paying this.
Even 11,000 you are not ready to pay. Assuming, not accepting at this date,
This document, Milord, is not seeing the light of day before any court.
You have not.
We are just testing his argument.
Correct. Because in that case, it was not tested. It was. They should have gone to the state redressal mechanism, which should be invoked. They should not have filed the license.
Why? You have done it.
They have to. Because under the Act, if they have a grievance, there is a redressal scheme under which they could have gone. They will have immediately filed a petition. Because I am not getting into whether the alternative.
The grievance is when you don't act properly.
Milord.
When there is an admitted position on record.
Milord.
So why your officers have not acted and implemented this?
Milord.
Why you have not offered 11,000?
Milord. Milord.
You are unnecessarily drawing these teachers into litigation.
Milord, that's not the case. Now, if your lordships will kindly see, right from Bada Bachao, your lordships have said the policy decisions, fiscal policy decisions, these are to be left, Milords, to the experts to decide. And any state government will cannot be sacked.
But we are experts of experts.
No, Milords are experts. Milords, I bow down. Milords, I am not getting into that aspect. I bow down. Milords, the kindly see, I have given the details, Milords. There are very few decisions, policy decisions, and how your lordships have interpreted it. The first one, Milords, is
Then we are aware of, but even then,
for the reason. Milords will have to have a holistic approach on this. I understand your lordships are having in mind that these are poor teachers. They they are working on contract basis, you are not giving them anything. That's not what we had tried. In fact,
First of all, you don't make regular appointments. You engage them on contract basis, time basis, part-time as visitor teachers. See, these are all nomenclatures you have devised because you are not able to make regular appointments. Whatever regular appointments you made,
under the schedule of the central government, the Act says part-time teachers. Part-time not doing.
yes,
Because if your lordships have the schedule,
very rightly
the part-time instructors.
rightly says part-time teachers because you won't be able to make regular appointments.
Because these are part-time instructors as per the Act we are making. We are keeping them. In Narmada Bachao Lutz, your lordship Lutz, if I'll just read, there are 3 paragraphs Lutz, as to what your
That
lordship
is on policy.
decision. Now Lutz,
You pass on the judgment.
yes, not I'll pass.
We are also aware of those.
Now Lutz, there is another judgment. I'll just give the ratio as to what your lordships are saying. That if there are contractual terms which are challenged, then such instructors or officers are stopped from challenging the terms after acceptance of the contract, which your lordships have held in state of Maharashtra versus Anita.
So only they are not challenging the terms of the contract. What they are saying is under the contract, the remuneration was fixed
Yes.
on a yearly basis.
Yes, Lord.
But subsequently, your own government is taking a decision, maybe a policy decision or maybe an administrative or executive decision, that these teachers should be given 17,000 per month.
Yes, Lord.
Why are you not paying that amount?
Because that
It is not a question of challenging the condition of the contract.
And it is paid for some time, and then abruptly they say, no, we are not doing.
things are there. We had decided, your lordships have always left it on the wisdom of the legislature to decide on these policy matters. If I will show certain judgments, when your lordships have said, as far as they are concerned, even for base,
When you make a policy which is apparently arbitrary,
I'll say why. It is not arbitrary. It is today, if this scheme is to be implemented by the state government only, with only 3,000 crores from the central government. Today, Willows, my responsibility is for that 17,000 crores. I have, Willows, budgeted myself, budgeted all my resources for at the max 8,000 crores. If I take the entire 20,000 crores as the outlay for this, I had computed myself for 8,000. Today, by virtue of this decision of paying by the central government only 3,000 or 4,000 crores, that additional burden of 8,000 crores is coming on me. The central government says, sorry, I have given my final amount. But today I am standing nowhere. The government is not going to give me money because they say I have paid. What they have paid to lead only 4,000 crores. So what about those 80? You are estimating my liability or my expenditure for 20,000 crores. It's your duty to pay me 12,000 crores. And today you say, sorry, I am giving you 4,000, I will not give you anything more. This is my full and fine. What will happen to that 8,000 crore? I have other things also. The greatest of respect. The government, the state government has not only this scheme, a central scheme is being run by me. And my state schemes cannot run because that 8,000 crore I have to take out from some. They are not giving me anything. Because they have said, sorry, end of the story, we have given full and fine. That cannot be used. The central government cannot say so.
file a petition against the union.
No, the government of India is here. The government of India has to say. They cannot shy away by saying that no, if you have given full and final, it cannot be full and final. Because if you are estimating it to be 20,000 crores, your estimate, your outlay is 12,000 crores.
As we say, that will be an issue been raised by state to the central government. You will raise that issue to the central government that provide us more finances or whatever you
Government of India is before you.
and it's really there.
If the government of India is before you watch it, then the government of India cannot say that that is the full and final 60% is 3,953 crores. Then the total
Ultimately, if the government of India makes available some more funds, you will increase the salary to 17,000.
not more their share.
Their share.
Their share has to be. I cannot do it.
We have no objection if they are paid 17,000, provided central government contributes more.
And Willows, it was our proposal which was sent to the government of India for making the salaries. It was not the government of India's suggestion. It was our suggestion.
Your suggestion. So,
Sir,
you will keep your this suggestion intact, provided government of India makes further payment.
the problem today is the government of India has come up with a 2018 order wherein they say like
So it is basically your grievance against the central government and not vis-a-vis the teachers.
because as of now, look, this is not teachers' case. I have to run the state. I have to run the state. The central scheme is to be
The state
implemented.
has to be run by curtailing the salary of the teachers.
Not that. Somewhere, look, there are a lot of things. Look, the state government has a lot of benefits. I am asked to run a central scheme without being paid. No, Milos will kindly see.
Compromise only. To compromise only in issues like education and health. You say that state have the limited resources, I have to make compromise with something, I have to curtail down the fund, or I have to make arrangement. Ultimately, it comes to the education.
Looks.
So, as far as the pressure, no, we are it's open.
Yes.
Ultimately, if you are saying that, it would be resulting in that you are saying that if the students in the state of UP are the sufferer, if they are not educated, okay, fine. I'll be happy with that because I have to maintain some other scheme. This can't be a state approach.
As far as these part-time instructors are concerned, at least not those. I'm not demeaning anyone. I'm not trying to.
IIT has to be given education.
Yes, Milos, it has to be Milos, but please, Milos, your lordships are. I'm again and again only reiterating Milos. A central scheme has to be run as per the norms, as per the act.
That
which
is
will not happen.
that we
And
want.
therefore, Milos, we cannot. Milos, the state cannot. Now, Milos, as far as the changing of the policy by the state government, your lordships have held that on the basis of the reality. Since your lordships are again saying about
The state government may vary.
Milos, your lordships have held that we have Milos the power. Milos, I'll give up those judgments.
Yes.
That what your lordships have said that on the basis of the ground reality.
Give the compilation.
Yes. So and
That's all.
Milos, as far as this honorarium fixation is concerned, Milos, it is also therefore close that it's a policy decision taken by the government.
No, it may be a decision, but there has to be some authority responsible for fixing the honorarium.
Yes.
Now, who is that authority responsible? It is not PAB.
Milos, it has to be.
No, you tell us.
7.2.
7-2, who is the authority?
Milos, under
Who is the
7.2,
person?
it says the central government.
Hmm.
It says, Milos, if your lordships have 7.2, the central government shall prepare the estimates of capital and recurring expenditure for the implementation of the provisions of.
Yes. Yes.
It is the PAB set up by the central government.
Now, all right. You tell us who is the authority, who is the person.
Therefore, PAB recommends, Milos,
Yes.
it can be a recommendatory body.
Right.
Ultimately, Milos, the government of India, how it is to be done, this PAB, can this PAB, despite knowing the fact, may kindly appreciate, despite knowing the fact that the entire budget of in under education of the central government is 23, can it approve for only one state 20,000 crores? The entire budget for the entire country is 23,500.
Friend talking a lot. Central government affidavit says 23,000 is UP. But let us let
Please
us
see what are you saying?
just see the affidavit.
I'm sorry.
Just see the affidavit.
Please see PAB's recommendation.
I'm sorry, please
I will
see
not
page,
read that affidavit.
please see page 508.
Don't argue among yourself.
Yes, yes, yes.
We have devoted more than 2 hours now.
Now, Vinod, kindly see the PAB's approval, what it says.
That is for UP only.
No.
Please, David, the state government's, central government's affidavit is at page 503.
You tell us the authority responsible for fixing the honorarium. Maybe PAB is a recommendatory authority, but recommendation has been made. It has been accepted by the Senate.
Vinod, I think, Vinod, for that, Vinod, the learned ASG will have to answer, because if it is the central government, Vinod, which has to do it, they have to say as to who are there, and what my learned friend had said.
We want to know, central government is all right.
But then if you had some doubt that PAB is not the body, why you accepted their recommendation?
Vinod,
You will see, Mr. Prasad, on one hand you say that.
Try to sail on two boats.
Vinod, if Vinod will kindly see that recommendation, what has been accepted.
Anything
But
can be
then
argued.
if your
The
objection,
authority of PAB is not challenged. Let him read any part of the High Court judgment. And here in the Supreme Court, you can stand up and say anything under the sun.
Yes, here you want regularization of it.
Mr. Prasad, see, if you're on that PAB is not a body, it's not a mandatory, it's something recommendation, it's only a regulatory body. You could have objected its recommendation.
You would have raised it in the High Court.
You could, if that was your stand, then you could have objected that recommendation. You are not objecting it, you are accepting it. And now if you are taking a stand, no, PAB.
Probably the only argument raised before the division bench was that this 17,000
Please continue.
is limited for 1 year. It cannot be in perpetuity.
Yes.
And all that what you are arguing was never argued before the High Court.
No, it was there. It is there. I'll read
No,
it.
it may
From
be
the
before
English
the
order itself, not from the grounds of the special appeal. In the ground, my learned friend had taken one paragraph. After that, the other paragraph says what we had argued. We had argued everything, not only the perpetuity thing, but even the 17,000.
main emphasis was on perpetuity.
So that, if your lordship sees the impugned order, at paragraph 45, I'll just take out the 25 and 26 minutes.
Para 25 is.
Yes. MC Chaturvedi's argument is there.
Huh? Page 19. Those para 25, it has been read, 26.
MC Chaturvedi, additional advocate general.
Correct.
Yes. Then paragraph 26, I'll read 25, 26 both minutes. It has been argued by the learned advocate general appearing for the state of UP along with Mr. So-and-so, appearing for the appellants in the two Lucknow. The learned single judge erred in issuing a mandamus directing payment of honorarium at the rate of 17,000 per month to the writ petitioners based on the decision of the project approval board dated March 17 for all times to come, in as much as the decision of the PAB and the proposal upon which it was found was limited to the year 17-18. Therefore, no direction could be issued for the subsequent years relying on that decision. Elaborating on this submission, the learned counsel appearing for the appellants points out that the Sarv Shiksha Abhiyan is a society registered under the Societies Registration Act. Each state, union territory managing the project has a separate society with its bylaws. The All India project is managed on a year-to-year basis with budgetary allocation in case of state and union territories opting for the Sarv Shiksha Abhiyan in accordance with their financial resources. The fund contribution towards Sarv Shiksha Abhiyan in the state of Uttar Pradesh is in the ratio of 60:40. In other states and union territories, the ratio may be different. The project, including making of appointments, is under the management and control of the state government. Part-time instructors engaged under the Sarv Shiksha Abhiyan are to be appointed on contractual basis. They are required to execute an agreement which inter alia provides for the amount of monthly honorarium payable for each year. The year-wise project implementation is dependent on the actual availability of financial resources in the relevant financial year, both with the central government and the state government. In June 2017, engagement of part-time instructors all over the state, including that of the writ petitioners, was reviewed on the basis of agreement entered into between the part-time instructors, including the writ petitioners and the concerned district basic education officer. The contract stipulated honorarium for the year 17-18 as 8,470. The project approval board on March 27, 2017 in their 250, I'm so sorry, para 27.
Yes, yes.
The contract stipulated honorarium for the year 17-18 as 8,470. The project approval board on March 27, 17 in their 254 meeting approved 17,000 per month as honorarium payable to part-time instructors for the year 17. But they did not release adequate funds commensurate to the central government 60% share of the total outlay. The figures have already been mentioned and need not be restated. The state government, upon receiving less than the 60% share of the central government, worked out on the estimate of expenditure on the project for the year 17-18, wrote to the Executive Committee Shiksha Pariyojana Parishad to review and redetermine the monthly honorarium payable to the part-time instructors earlier fixed at 17,000 per month. Accordingly, the proposal to pay honorarium at the rate of 17,000 per month for the year 17-18 to the part-time instructors was fixed at 9,800 per month. That is to say for 11 months up to the year. Now, upon an overall advantage of the appellant's case, the contractual nature of appointment and the honorarium to which the writ petitioners and other similarly situated part-time instructors have agreed to in terms of the contract they have signed have been much emphasized. The appellant says that the writ petitioners are contractual part-time employees and are bound by their contracts. They cannot ask the court to look into what transpired between the central government and the state government in the process of fixation of the writ petitioners honorarium and how it came to be scaled down from 17,000 to 8,470. Each of the writ petitioners and all part-time instructors have signed contracts for the year 17-18 agreeing to receive.
For every year there is a separate contract.
Yes. 11 months only. It's only for 11 months.
And in each contract the amount of honorarium is mentioned.
I will show the
Show for the year 2017.
Yes. Kindly come. 206. 204 of the state's SSC.
Same. 204.
Lordship, please.
Oh, 204 is not the page.
Yes, Lord, in fact,
State SLP.
this is in the state's SSC. I'm very sure. Because if your lordships have the this UP Junior School Instructor Association's case at page 82 and 83.
82 and 83.
Yes.
Yes.
Now your lordships have the service contract. Page 82 of the paper book.
No.
Your lordships have which paper book? Which the Mr. Patwalia's paper book?
Yes.
Page 82. Annexure P2.
This is for the period 14 to 15.
Milos, may kindly see item number 4.
4.
8 of Milos, may see.
Years completion of the agreement 31st May 25.
Yes.
15.
Milos, may
And
kindly
it
see.
starts from 1/7/14.
Milos, may kindly. I'll read. Name Vikram Singh.
Yes.
Post Anudeshak, that is instructor. UPS Narayanpur. Date of joining 1st of July 14. Subject date of completion 31/5/2015. This agreement is made for.
This was for 7,000.
Yes, sir. Yes.
Now, what is the agreement for?
Milos, page 204, Milos,
Of state SLP.
of state's SLP. Anurag, the petitioner herein before your lordship, in one of the SLPs, I'm sorry, it should have been a typed copy.
No. Page 204, part-time
Yes.
instructor service contract.
Yes, please.
Now, where is the amount of salary mentioned?
Yes, Milos, may kindly see. Milos, may.
The agreement such and such.
Milos, if your lordship sees item 1,
Yes.
the Zilla Basic Shiksha Adhikari shall pay the employee at a fixed honorarium of ₹7,000 only per month. Item number 1, Milos.
And actually paid is 8,470.
How?
Actually paid is 8,470.
So
That
that is a
year-
stereotype agreement which you
That year
drafted
they have paid us 8,470.
when the initial appointment was there. but you yourself keep on increasing the salary.
So, my lords, if I have increased, my lords, from 7,000 to 8,470.
This is just a format, they keep on making us, this is the height of exploitation.
Sorry, my lord, it's not
Height of exploitation.
No one had put a gun on his head to sign this contract. He has signed it on his own free will, my lords. I'm sorry to say, this is, my lords, this is not fair to say that you have free signed. Yeah, a lot of people, my lords, their advertisements were issued. It's not that he did not know the terms before signing, my lords.
For subsequent year.
He is signing for subsequent years.
You make recovery of whatever excess you have paid. Above 7,000, whatever you have paid, you make recovery.
No, I'm not at all suggesting that. That's not the case of the state government. That's not right.
These are the stereotype formats you keep and just ask them to sign. No, we are not saying they have signed it under compulsion or anything. They may have signed it with their free will, but they are aware because every year you are increasing as per the recommendation. Now for this year 2017 onward, the recommendation is 17,000. Why you will not follow it? Only because funds are not being made available.
Because in fact,
That is no ground. That is your internal management. You fight for the funds with the central government.
what we had argued at paragraph 28 of the impugn judgment, the very
20 paragraph.
paragraph 20.
Central government share is not there.
Anything new you want to add? Otherwise,
As far as this aspect is concerned, nothing numerous, the judgments I have, because I'll give that.
whatever judgments you are relying upon, you just give the compilation
Yes, Lord.
on subject wise.
As far as perpetuity is concerned, that aspect, the High Court has, the division bench has simply said that because it's a contract, annual contract, the court cannot go into this aspect, that it should be given from 17 up to.
No, but what was the recommendation? The recommendation was
Only
only for
that
the,
year.
no.
Yes,
Show it from the recommendation.
please see the PAB's. Please come to the PAB's recommendation. Which one? 206, page 206 of the state's SLP. It page 206.
Yes.
That Lordships have 15th May 2017. The 254th meeting of the Project Approval Board of SSA was held on 27th of March 17 to consider the annual work plan and budget of Sarv Shiksha Abhiyan scheme for the state of Uttar Pradesh during the year 17-18.
Come to the relevant part.
Yes. And then, my lords, what your lordships want to see is at page 219, internal page 14. Look, this is only for 17-18.
No,
The entire.
no, part-time.
The PAB estimated at page 219, internal page 14. The PAB estimated, I'm so sorry, page 219, internal page 14. It says, my lords, after grand total estimated budget 17-18.
In part-time, there is a separate.
Yes, that is the last page, 234. That is 234 to 35.
Yes, teacher cell.
Yes, that is the last two pages. This is only for 1 year, my lord.
Part-time teacher.
Now, my lords,
11 months.
yes, this is the chart.
And what is the recommendation for the next year? What is the recommendation for the next year by the PAB?
Looks for the next year. Kindly see, as far as this is concerned, it was only for 1 year.
All right, we accept, but what is the recommendation for the next year?
Next year,
See, if you are making these recommendations only for 11 months, then there has to be a regular recommendations every year.
Next year, they will say 7,000.
Reconsideration.
I can, I'm sorry to say, but yes, I can. Even if
The
they,
salary which is determined by the board is the approval may be for 11 months because their contract is 11 months. Apart from us, there are, just see page 29 internal, primary teachers existing in 12 months, primary teacher 11 months, primary teacher 12 months.
Yes.
These are the contract, the fixed ones.
Yes.
Otherwise, there are other teachers. Once the salary is determined, till it is re-altered at a later stage,
No,
you
that's
cannot.
why we are asking.
Yes, this-
Now, this is for 2017.
17, 18 only.
Now, what is the next recommendation?
Look, yeah, who has it? Who has it? Because I think it's in the order.
There is nothing in the order. They haven't taken it to the floor.
It has been done, so I'll just give.
All right, we hear Ms. Bhatti, then we will come.
I'll just take it.
You find out and let us know.
Yes, please.
Yes, Ms. Aishwarya Bhatti.
But your option permit that I must report.
Please.
The union has filed a counter in 1.2 and that was in the state of UP.
Yes. No, what is your defense?
Let me read para 9 first. That they exist.
Page.
Page 2 of the counter.
Yeah, 1.2. Yes, paragraph.
Para 7.
89.
Yes.
Department has launched the Samaj Shiksha and Integrated Scheme from 2018 and 19. The scheme has now been aligned with the recommendations of the NEP 2020 and has been continued for a period of 5 years. Then your lordship for the pattern of the scheme may see pattern 9. The existing fund sharing pattern is 60-40 for all the states. The exception that the pattern will be 90-10 for northeastern and 3 Himalayan states and 100% for the union territories without legislation. Then your option may come to para 19. That during 2017-18, the PV of the department estimated a total amount of rupees 2688.13 crore under SSD, out of which for 30949 part-time instructors at the rate of rupees 0.17 lakh per revenue, as proposed by the state. You'll also then the minutes of the PAG meeting are introduced.
Which page?
Paragraph 9, page 20.
Page?
कभी नहीं भेज दिए, कभी आपको decide.
We would have 60-40.
You got your paragraph 20.
There is nothing in your counter.
You got your paragraph
Only that 40-60, that has.
There is a complete table that what are the amounts have been disbursed to the state of UP. There is an unspent balance.
We are not concerned with the amount released or not released.
So the center just releases the fund.
The only question is why 17,000 as recommended was not paid.
Because it is up to the state to pay the payments. The center releases the amount to transfer. It is for the state to decide all the salaries returned.
What we have been saying.
Interesting.
Paragraph 20.
No, you have the copy of this affidavit?
2.1. 1.2.
Plus 1.2 would be Anurag versus state.
Yes, yes.
One hand, your grievance is that the central government is not providing the sufficient funds, making you there difficult. And now this table shows that certain allotments which are made, there are some amount which is unspent. That is a table supplied by the Union of India. Come to the very first table, the 80. Yeah, explain. 1890 ऐसा ही है. Come to page 8.
Yes, I got it.
Now this is a statement for year 1890. But certain amount which was distributed in the share of state of UP, out of that some amount is unspent.
1890 non.
Maybe we are on the issue on one hand, when the central government is providing you some fund budget allocation, amount is not fully utilized for the elementary education. And this amount is for the elementary education for the year 1819, out of which state shown rupees 55,277.70 lakh as unspent balance.
And this is for all years.
It cannot be, the fund which is being allocated under one heading, cannot be used by the state government. It cannot.
So therefore, you are not accordingly making your schemes as to have an effective utilization of the government funds, central government funds. If you are receiving funds, is it not your duty to see that you make out your plans so that an effective education education policy is implemented effectively? On one hand, if you say that, sir, we are short of funds, other hand, if you are not utilizing the funds, then how you can proceed with these schemes which say that beneficial schemes? You should at least see that lesser and lesser amount kept unspent, and most of the amount is utilized.
If your lordship sees what was the central's release, it was 46,000 crores, if I am not wrong, out of which.
Sir, we are on the issue that on one hand, you are not in a position to allocate funds for a specific purpose, utilize it at least for more than 80%.
It is.
55,277, why it should be unspent? If you are having these schemes, certainly you can utilize it. Roughly, we take it roughly, maybe even 20% or 25%.
Yes.
Why 25%? You utilize it for the purposes.
That is why it happens, because these are budget estimates.
So there is no proper scheme management also to see that you prepare a budget. These are schemes.
Yes.
At least this amount or approximately this amount for the head under the heads. You will get funds from the central government. If accordingly you are making plans which are, if you are focusing on education, then why on one hand you are unutilizing the funds and on one hand you are then making a complaint that the central government is central government provides fund, you are not in a position to utilize it.
Because I understand. Now, as far as these funds are concerned, why it could not have been used? Today, it's very difficult for me to give a statement as to why it remains unspent. There may be some capital expenditure for which estimate would have been given. I cannot, as of now, make a statement.
We are only concerned that if you are getting funds, as a state, one of the biggest states in the country, and if you are getting some funds from this government, you make your plans accordingly, utilize it. Our concern is that if money is there, please utilize it for the better purposes like education, health services. Don't compromise and then don't make complaint that we have to compromise or short of funds.
In fact, the government of India should have also given for the financial year 17-18. Now, Yes, but
So 17,
It
18,
was
they have
17, 18 unspent balance.
yes, for the reason that, look, because the funds for other purposes, for the salary, why it was, this statement is here, why it is there, I cannot.
We are only on a broader.
Yes, your lordships are right that if you are sending a budget and an estimate.
Unutilized funds,
getting
that
the
amount
money,
goes back
I-
to the, that amount goes back to the central government.
Lords.
Unutilized fund,
Yes, please.
it can't be rolled out for the next.
Lordship, please.
Carry forward is not there.
Yes, my lords.
already you complete your sum, please.
Lordship parashut.
Paragraph 24.
There is unspent balance in 2022, 2029, 2021, 2020, 2019.
So paragraph 24.
Lordship, that the recruitment, service commission, deployment of teachers and payment of salaries are primarily in the domain of the respective state government, and the part-time instructors engaged by the state of UP by way of conduct are to be paid according to the terms and contract between the state government and the teacher. And then your lordship, the Samarth Shiksha scheme is reproduced in Extra CA1. It's 6.9.14.1 teacher recruitment, page 19.
Teachers.
Yes, 6.9.14 teacher recruitment. This is the last line. There is a need to deploy quality teachers in the remote and tribal areas to achieve holistic and inclusive quality education. The state UPs need to ensure adequate number of subject teachers.
No, you are reading under part 6, heading teachers.
Teachers recruitment, part 6.9.14, end of the page 19.
We don't have page 19. 17 is the, 18 is the last page.
The next is
इसको देखिएगा पूरा करा दिए, मिसिंग है पेज.
One page is missing.
Thank you. We are reserving the judgment.
Great aspect. My lord, it has never gone back to the PAB.
No, you.
PAB decision, I'm not on that.
No, no.
Your lordship had said about the next
year.
That is there.
What is the recommendation? Salary
The
recommendation?
next year it was 7,000.
7,000.
Yes, for 18-19. It was 7,000. 7,000 unit cost for 11 months, 77, which your lordship will find. In my lords, the UP junior school.
Yes, it is 7,000. Till 21, 22, it is 7,000. And then again it rose to 9,000.
Correct. But it has never gone to the PAB. This is their own doing within the state of.
Sir, the recommendation.
No, not at all.
Their reconsideration.
Not at all. It has never gone to the PAB.
Right.
Yes.
Look, kindly see the counter affidavit of the Union of India. It says this. So why my
That is, it has never gone to the PAB. I am making a statement with responsibility, not just saying anything and anything. Number one. Number two, the central government's affidavit says that is our maximum cap on contribution. Great. Lord, there is one judgment which I want to cite additionally, Lord.
Whatever.
That is that Ashok.
You have passed on the judgments.
Yes, just one more.
One more.
That is
All right.
I'll just give it in writing. That is Ashok Thakur's case, my lord. Para, that is in the context of right to
Ashok
education.
Thakur's case.
Ashok Kumar Thakur, that constitution bench, that is para 435.
What is the citation?
2008, volume 6, SCC, page 1, para 435. In addition to free education and financial assistance, they should also be given books, uniforms. This is in the context of primary education and necessary benefits so that the object of 21A is achieved. Time and again, this state in a number of judgments has observed, state cannot avoid its constitutional obligation on the ground of financial liability.
Yes.
3-4 judgments are cited. This is exactly what the Honorable Chief Justice says in his judgment under appeal. Grateful, my lord. Very grateful.
This part that your lordship will ask.
You give a
I will give
3-page synopsis and the compilation of the judgments you want to rely
Let me
upon.
give that. What my learned friend is saying is that it was never approved. In fact, India rejoined itself. They have put in this document.
We will look into it.
I have not, they have filed it.
It has never gone to the PAB,
It
is what.
is approved by PAB.
We will examine that as
Yes, please.
within 3 days.
Yes.
Written submissions within 3 days.
Within 3 days. Great.
We come after lunch.
My Lord's permission, Manoj, item 43 is a fresh matter, Manoj. There's some urgency in that, Manoj. There's a case of Bharat Petroleum where
Maybe, but let us see. We come after lunch and we try to take it up.
Manoj could take it up at
Item 10 and requiring 4 weeks accommodation. Your Lordship.
Item 10,
Yes, madam.
4 weeks.
Manoj, if Manoj could take it up at 2 p.m. because there's an amendment which has been allowed
No,
after.
after 2 p.m. we will consider. Come after that.